Hi everyone. To quote Janet Jackson, I still miss you much. Unlike Janet Jackson, I am not going to be dancing for you. What I am going to do is I'm going to walk you through the CREAC format. Some of you learned it in LF. If you took my class, if you took Professor Cheng's class, we definitely taught you the CREAC. I don't know if Professor Cheng calls it the CREAC, but she definitely taught you that format. So to get you ready for your memo, your memo about Pia and her immigration problem, I'm actually going to walk you through the Li matter. So we're going to wrap that up, but in wrapping it up, we're actually going to be looking forward as you tackle the immigration problem. I do want to say, before we start, there's some talk here at the law school about the semester going to credit, no credit. My experience with credit, no credit is that the students take the research and the writing assignments a little bit less seriously, but I would kind of impart on you and implore you and plead with you not to do that. Please treat the immigration memo as though you were being graded, regardless really of what the school decides. And for many reasons you would do that. Research and writing are skills that you really don't show up to your job with. You need to practice them. They don't all of a sudden appear for you, and you can't call them up when you need them, particularly when it's urgent. And an urgent time to need them would be this summer when you're working for your various employers. They're going to expect you, for the most part, and depending on who you get, depending how much they handhold, they're going to expect you to be able to demonstrate those skills, and you can't call them up when you need them at the last minute. You need to practice them. So, take the immigration problem seriously. Treat it like it's graded, whether it is or not, and really practice your writing skill. And then I will, give you heavy comments so that you can then turn it into a writing sample. The thing that's really great about this assignment too is that it's a federal issue. Oftentimes a federal problem makes a better writing sample because federal issues often are more complicated and intricate than state law issues. And the other interesting thing about this problem, and it's really unique in that way, is that you actually are dealing with state law issues as well. So the problem is this sort of interesting sort of hybrid of federal law and state law in one brief, which will make for a really excellent writing sample. And the other thing I want to remind everybody is that even though this is how the class is going to go forward, and this isn't an ideal way to teach research or writing by any means, I just want to just remind you that I'm always available, whether you want to come into the law library. Right now we're open, or if you want to set up a one-on-one Zoom. I think one-on-one works best when you're learning the research skill and particularly the writing skill. So please set those meetings up. And the other thing I want to remind you is, for me, if you want a great resource for learning how to write and also use your research to support your writing, my favorite book on legal writing is A Lawyer Writes, which is this one right here. So check this one out. I'll refer to it at the end of this lecture as well. So actually, why don't we do that? Why don't we actually start looking at the Li Memo? So it would be great actually if you guys followed along with the Li Memo. You should have it. It should be on the twin page. So you might want to follow along as I go through the different sections. So let's actually talk about the Li Memo. When you look at the first page, you've got the caption. So we have the caption here at the top, and we've provided you the caption for the immigration memo. The question presented and the brief answer I will discuss briefly, only because you will not be writing these. For the immigration memo, you're actually going to write something that's called an introduction, essentially, the introduction, as you will see later, is the question presented and the brief answer combined, and I'll show you how that works. But for the question presented, you literally will stack the questions on top of each other. The Li Memo had 2, and the questions in the Li Memo didn't really relate to each other very much. One was about burial laws and property laws, and the other one was literally a contract issue. So we had 2 separate issues, and that'll be reflected in the memo as being Roman numeral 1 and Roman numeral 2. For your immigration problem, for the most part, you have 2 issues, but they're closely related. So because they're closely related, you essentially are only going to have a Roman numeral 1 for the standard of review, and a Roman numeral 2 that will be broken down into an A and a B for the Roman numeral for the Roman numeral 2. And we'll get to, I'll show you that visually as well on the screen. So when you notice in your question presented, it's actually stated as a question, and you are putting the most determinative fact in with language of the rule in both of them. And then in the brief answer, you are essentially answering the question presented in the very first sentence with a because statement. So here we have the fact that it's not violating Hawaii law, and the reason is dropped in with a because statement because the burial site was inadvertently discovered and immediately reported. So you have the language of the rule, which is this idea of being inadvertently discovered and immediately reported, and you have it woven together with the fact that moeapu were unearthed, and that there was a discovery of a burial site. And that's what you're always doing in your conclusory sentences. This essentially, since it's answering the question, would be considered a conclusory sentence. You're always weaving together the important language of the rule, inadvertently discovered and immediately reported, and you're weaving it together with the determinative facts or the important facts of from your issue. Here, the unearthing of moeapu and the fact that there was a burial site discovered. And then right after the answer to the question, you go right into the general rule or the important rules, depending on how many you have. Here we had within the Iwi Kapuna issue, we actually had 2. We had to talk about the burial site, so you had to put down the traditional and cultural rule related to burial sites, and then we also had the issue with the inadvertent discovery, and you had to drop down the rule for the inadvertent discovery. After you drop down your rules, you have to go into your brief application, and again, this is a brief answer, so your application has to be pretty concise. We start, and we know that we're starting the brief application because it uses the word here. And so here, and then you're dropping down your brief application. Here, the moeapu mark a burial site because the hand-carved bowls, burial kapa, and gourd constitute items that may be buried with Iwi Kapuna. So notice here again, you have your application of the rule to the facts. So when you apply the rule to the facts, you always have to have your because statement, and you always have to use language of the rule and weave it together with the relevant facts and the determinative facts. After you do that for each piece. So then you're going to do the application of rule to fact for the discovery of the burial site, and also for whether or not it was an inadvertent discovery. So then the next sentence moves on to the discovery is likely inadvertent, and then here's your because statement. Because the Li family's ground disturbing activity to fortify their home structure resulted in unanticipated finding of burial goods. So again, you have the important language of the rule, the inadvertent discovery, and you're weaving it together with the important facts that represent the inadvertent discovery. The important facts that show this is that the Li family's ground disturbing activity was used to fortify the home structure. And then what you do is that you then conclude and you bookend your brief answer. So the last sentence in the brief answer is actually functioning as a bookend. It answers the question again, and it then summarizes the application of the rule to the fact. Here, our brief answer has two brief answers because we have two different issues. I'm not going to walk you through the contract one, but just know that the brief answer works essentially the same. Your first sentence answers the question with your application of rule to fact by including a book cost statement. This student actually didn't include the book cost statement, but the student does include it at the bottom here, which essentially functions as the bookend. So then after you do that, you go into your statement of the rule. So here's the rule for impossibility. And then you drop down the rule for when the loss or the damages could have been foreseeable. And then once you drop down the rule, you then drop down your application of the language of the rule and apply it to the important facts. And that's what that does here in these two sentences. And then in the last sentence, you bookend your brief answer by restating and reapplying the important language of the rule to the facts. And then moving on to the statement of facts. The statement of facts, the very first paragraph, and you will do this in the immigration problem as well. Notice that the very first paragraph is essentially telling the reader, and for a interoffice memo, the reader is your supervising attorney or your partners or your associates. For the brief that you're writing, the reader is a judge because you're filing it with the court. But regardless, that very first paragraph is essentially telling the reader quickly what the issue is for the client, for your client, and essentially what the client wants, what justice the client is seeking. And you do it briefly. It's usually about 2 sentences. And then after, like for us, we indicated that the Li family wanted to determine whether they violated Hawaii cultural and burial laws, and also whether or not they could seek a partial refund. So that's essentially what our client was seeking, and you just drop it concisely within the first paragraph. And then you move on and you start telling the story. So after the first paragraph, you then go and start telling the story and supplying all of the relevant facts that you're then going to use later in your fact-to-fact comparison within your analysis. The thing to keep in mind too is notice that you have multiple paragraphs on the page. So please think of your statement of the facts as being a story, and please organize it in a way where it actually is something that reads like a story grammatically, reads like a story narratively, and in order to do that, you're going to actually have to pay attention to the way that you group information in the paragraphs that you choose. So please do that. And then notice too that once you get through the statement of facts, you come to the last paragraph. And the last paragraph essentially functions as bringing the reader up to speed with the conflict between the two parties. So for us, what brought the reader up to speed was that very recently, the State Historic Preservation Division halted the excavation of the project. And then notice too that you bring the reader up to speed, and then you also remind the reader what the client is looking for. So here the Lees would like our help to determine if the excavation of a potential Native Hawaiian burial site violates state law, and if Deke owes the family a refund for the work stoppage. So also notice too, another recurring theme in a lot of legal writing is that you use your writing, and within each section, you have these bookends. So this paragraph at the end of the statement of facts is very similar to the first paragraph. of the statement of facts. And you're going to notice, like, throughout the various sections of legal writing, you often use this bookend device. And we saw that bookend device when we were looking at the brief answer. And you're going to see the bookend device used throughout the discussion as well. And I'll point that out as we move on to the discussion. So in the discussion, notice that we actually are going to have a Roman numeral 1 and a Roman numeral 2, only because we have two issues that are actually pretty distinct from each other. If the issues were not distinct, we actually would only have a discussion section that included probably only an A and a B, because you would only have a single issue. So if you have a single issue, you actually would not put a Roman numeral at all. And you would actually function with using an A and a B if you had two separate issues that were related. But because we have here, for the Li family, we have a burial site and cultural issue for the Roman numeral 1, and then we have a contract issue. The contract issue would have to go into a Roman numeral 2 because it's so distinct from the first issue. But regardless, though, the format and the sections within each of the Roman numeral 1 and the Roman numeral 2 are the same. So for your discussion, when you're starting your first distinct issue, you have to start it with an overarching conclusion. So this is our overarching conclusion for the E.V. Capuna issue. So we have a court will likely find, and so this is the language you're always starting with. So for an objective writing, you're always saying that a court will likely or will not likely. For persuasive writing, you're actually going to use the phrase that the court should. So here, we start with the court will likely, and then we say will likely find that the discovery of Moepu does not violate Hawaii state law. And so now here is our because statement. So because, or any word similar to the word because, since, hence, therefore, when, so. So since no E.V. Capuna were found and the excavation of the burial site constitutes an inadvertent discovery. So this overarching conclusion, which is actually written in the header, and this might actually be something new that you guys have not experienced before. So instead of it appearing in the first sentence or within the text, you actually put the overarching conclusion in the header, but it still functions the same way. You indicate what the court will or will not find, and then you actually drop down your because statement or something that's analogous, and then you start weaving together the relevant language of the rule with the important facts that highlight the rule, as it's done here. Oops. And then in the next sentence, you actually, in a way, reiterate the ideas from the first sentence, but you do it as a transition into the overarching rule. So when you leave the overarching conclusion, your first sentence before you get to your rule, because our rule starts with the Constitution since it's the highest authority, your first sentence actually reiterates some of the ideas of the overarching conclusion, but merely as a transition. But notice that instead of writing it from the perspective of the court, you're writing it from the perspective of your client. So then here it becomes the Li family did not violate Hawaii law, and then you drop down your because statement. Because the burial site had not been previously identified, the work ceased immediately, and the inadvertent discovery was reported soon after. So this actually transitions to the rule statement. It also brings the rule and speaks of it from the perspective of the client, But it also, notice that it also steps out and includes more information than the overarching conclusion. Notice that this idea about the burial site had not been previously identified, the work ceased, and the inadvertent discovery was reported soon after. Notice that all actually is part of the inadvertent discovery, which you discussed, or which was discussed in the overarching conclusion. But it's mentioned in the overarching conclusion, and here you actually step it out a little bit more and include some of the language of the rule about the inadvertent discovery, which is that the work has to be ceased immediately and it has to be reported soon after. And then once you move on from that transition sentence, you actually start funneling your rule. So here the rule is actually going to start funneling from highest authority and then narrow down to the authority that addresses the very issue that we're talking about. So here we have the Hawaii Constitution is the highest authority for the E.V. Kupuna issue. We state the authority and then we provide the Blue Book citation. Notice that not only have we provided the Blue Book citation, but we also provide a highly regarded treatise as a seat also within the citation. And then once from the citation, we then drop down to the statutory law, because the statute would then be the second highest authority. We go to the statutory law that applies to both issues, that applies to both the E.V. Kupuna issue in terms of being a burial site, but also the E.V. Kupuna issue as it relates to inadvertent discovery. So all of the laws that apply to both of those are going to go into what is essentially your overarching rule. And then we cite the Hawaii Revised Statute, and then turning to the next page. So we actually come then to what's called the roadmap sentence. The roadmap sentence starts off with this language here where it says, this memorandum will show. And then you're essentially going to tell your reader exactly what you're going to discuss and what important facts will actually support that argument. So here, the roadmap says, this memorandum will show that a court will likely find the Lees did not violate Hawaii state law, because although the unearthed moepu indicates a burial site, it constitutes an inadvertent discovery that DEEC reported in a timely manner to DLNR. So the important language of the rule is that the Lees did not violate Hawaii state law. And the reason why is because they unearthed moepu, which is the important fact. So even though they did this, so the unearthed moepu is the important fact, it indicates a burial site, which is from the statute. But even though they did this, it constitutes an inadvertent discovery that DEEC reported in a timely manner to DLNR. So the inadvertent discovery is the language of the rule, and then you wove it together with the important facts that DEEC reported the discovery in a timely manner to DLNR. So this is telling the reader essentially what determinative facts you're actually about to use in support of the important parts of the rule. And then notice that on this screen you can see that the two subparts to the E.V. Kupuna issue, whether or not the discovery is a burial site and whether or not there was an inadvertent discovery, actually is broken into a subpart A and a subpart B. And together they equal the entire discussion. But even though we are breaking them into subparts, both of the subparts are still going to follow the same CREAC format. You're still going to have a conclusion, you're still going to have a rule block, you're still going to have a case explanation if there are cases, and you're still going to have an analysis, and you're still going to have another conclusion. So let's actually look at the first one, the first subpart A. Now what you'll notice though is that subpart A, there actually is no case explanation, because actually for the determination of whether or not there was a burial site, there actually were no cases that were adjudicated that actually handled the issue and interpreted the burial laws in Hawaii. So here you're actually without case interpretation. Here you're actually just going to use a rule-based analysis because it wouldn't be proper to use another jurisdiction's laws, because the iwi kupuna issue is so unique to Hawaii that it wouldn't really make sense to go to an outside jurisdiction. So you're actually going to do a rule-based analysis where you are just going to make the argument that the rule applies to the facts in this way. And I'm going to walk you through that now. So even though we were in subpart A still gets its own conclusion. So we have a court will likely, and then you indicate what the court will likely do. A court will likely find that the moeapu or burial goods that mark a potential burial site under the authority of DLNR. So this is your conclusory sentence. And then the transition sentence at the beginning, before the rule, says the Li family has unearthed a potential burial site because moeapu were traditionally buried with iwi kupuna. So notice the transition actually steps a little bit further, steps the rule out a little bit more, because it includes this because statement, because moeapu were traditionally buried with iwi kupuna. So it's forecasting what the argument is about to come before you then transition into the rule. So now you have your rule block here. So your rule block is going to be here. And notice that the rule block includes everything you found in your research having to do with the definition of a burial site. It drops the definition of a burial site. It then supplies the citation and the short form of the citation. It then transitions into the definition of a burial good. That also was discovered in your research. So you drop down the burial good definition, and then you drop down the important cultural piece from the Native Hawaiian Law Treatise, which was moeapu were traditionally placed with iwi and commonly included food, ornaments, and/or items special to the individual kupuna during his lifetime, and that was from the Native Hawaiian Law Treatise. And then in the very last sentence, you have, given that the Li's property is likely a burial site, since iwi kupuna are commonly found with moeapu, SHPD is the appropriate overseeing agency. So then you're just finishing the rule block with providing the authority, providing which agency is the authority to handle the entire issue. That becomes important because it needs to be reported to the agency in a timely manner. Now, normally after your rule block, if you had cases, you would then transition to your case illustration. But here we're actually just going to transition to the application of the rule using a rule-based analysis, which is you using the language of the rule yourself instead of a prior court opinion, and actually plugging it in to the determinative facts that trigger your rule. So here we have, while iwi kupuna were not yet found before Deke had ceased excavation, it is reasonable to believe that the 3 hand-carved bowls, burial kapa, and gourd are over 50 years old, and that these items were intentionally placed with prehistoric or historic human skeletal remains at the time of burial. Your very first sentence in your analysis should be a conclusory type sentence, like this one is, that tells the reader what you are about to apply, what you are about to analyze in the next consecutive sentences. So your very first sentence in your analysis should essentially conclude as to the forthcoming application, but it should be brief. This one might be a little bit long, but it should be brief because the rest of the paragraph is going to do most of the work for you. So once you have the setup, it then just becomes expounding upon the conclusory sentence. So you're going to hit on all the points that the conclusory sentence sets up. So the next sentence expounds on the conclusory sentence in the analysis. The bowls and the gourd are items that would have been intimately used by a person and could reasonably symbolize special items to be buried with an individual. So the bowls and the gourd is the relevant fact. And then the fact that they're intimately used by a person and could reasonably symbolize special items to be buried with an individual, that comes from the Native Hawaiian Law Treatise. And so that is going to become the relevant language of the rule. And then you move on to the next sentence, which is developing the analysis. The presence of burial kappa is also a strong indicator that these items were intentionally placed with human skeletal remains at the time of burial. The presence of burial kappa is the important fact. You're weaving it together with the language of the rule, which is that these items were intentionally placed with human skeletal remains. That is also coming from the Native Hawaiian Law Treatise, which actually helped you understand all of Hawaii's burial laws. And then finally, you have the last sentence where you have additionally, even though iwi kupuna have not yet been found, the discovery is likely a burial site and more than 50 years old, since the Li's property lies along the rail line in an older neighborhood in Kali'i, where several other historic sites have been located. So this one too, so notice that you're qualifying it with even though iwi kupuna have not yet been found. You're then saying the discovery is likely a burial site and more than 50 years old, and you have your because statement. So this is all from the language of the rule. So the idea of whether or not iwi kupuna are located, that was in the language of the rule, which you guys saw in your class exercises. The discovery of the burial site, you have a burial law about this very discovery. And then you also have the language of the rule saying it had to be more than 50 years old. So this is all the language of the rule. And now you're going to plug it into the important facts. And you're saying that this is evident because the Li's property lies along the rail line in an older neighborhood in Kali'i, where several other historic burial sites have been located. And this becomes the important facts that are being used to actually support, and also you're using them to show that this language of the rule is being triggered. So this language of the rule is being triggered because these facts are in existence. So this is you tying together or weaving together the important language of the rule with the important fact that highlights or triggers the rule. And you're going to be doing that throughout your analysis. And then because the parts get their own mini CREAC, we have to then finish with another C. So you're just going to conclude as to that part. And to conclude briefly, so your thus and your therefore statements do not have to be very long. They can be short because you've already done all the hard work above. So this thus therefore statement should be pretty short as it is because you've done all this hard work above. So you don't need to then restate it verbatim below here. So this can be short. And then you move on to the second subpart, which is subpart B, and we'll go through this one faster. So, but again, notice that the header is your conclusion. So this is your mini conclusion that only applies to subpart B. So a court will likely find that the Li's excavation constituted an inadvertent discovery. Notice you have the because statement. So inadvertent discovery is the language of the rule. Here's your because statement that's then going to connect it into the relevant fact. So because they did not plan to or anticipate finding burial goods. So language of the rule, because statement is the glue or the connection into the relevant fact. Because they did not plan to or anticipate finding burial goods. So once you do your mini conclusion here, you have to then go into your rule. But stylistically, it helps when you just kind of have a transition, a cleaner transition between the overarching conclusion and the overarching rule. I'm sorry, the mini conclusion. Here you have a mini conclusion. So it helps to have a transition statement, a transition sentence between your conclusion, whether it's an overarching one or a mini conclusion, and your overarching or your mini rule. Here we're dealing with mini rules. So here we have the Lees hire Deke to reinforce the structural integrity of their property, not to excavate a burial site. So this is going towards, this is also supporting the fact that it was an inadvertent discovery, because the relevant fact that they did not plan to or anticipate finding burial goods is that they hired Deke to reinforce the structural integrity of their property, not to excavate a burial site. So this will function as, so this goes a little bit further than the overarching, than the mini conclusion, but it also functions as a transition between the mini conclusion and then the mini rule that only applies to subpart B for inadvertent discovery. So then we go into the mini rule that actually discusses the rules for inadvertent discovery. And notice that your rules go into the relevant section where they're only being addressed. So notice that in the burial site subpart, all the burial site rules did not appear earlier in the overarching rule. They only go in the subpart if you have a subpart that is relevant to the rule. The same thing here for inadvertent discovery. Inadvertent discovery is only discussed in subpart B because it only applies to the parts of the rule and to the facts that discuss inadvertent discovery. It makes it easier for the reader of your work to follow the law if you keep everything relegated to the relevant parts of the law. That's both rules, facts, and the application of the rule to the facts. You keep them sequestered to the relevant section to help your reader's comprehension. So let's continue here. We'll just look at the mini rule. The mini rule starts here. We go to the next page. So you drop down the inadvertent discovery rule, which you found in your research in the Hawaii Revised Statutes. Notice, though, that you have the statutory law first in the citation with the semicolon, and then you have your regulation. So the regulation will fill in the details and provide more context and more explanation for the statutory law, which is often broader. And then you continue it, and you say, if discovered, all activity in the immediate area must cease, and the discovery must be reported as soon as possible to avoid suffering penalties. Notice, too, that we're including the statutory code section in front of our code section here, and the reason we're doing that is to avoid confusion, because there could be confusion since here within these two sentences, you've talked about statutory code sections and regulatory code sections. So to avoid any confusion, you would actually indicate that this is a statutory code and not a regulatory code. So here we're still doing a rule-based analysis. So, and we know that we're in the analysis because it's saying here. So because we're rule-based, we don't have any case law that is expounding upon the rule of law. So we're going to turn then to the language of the statute and the regulation and apply it to the facts that we have. So we go right into it, but we first, before you do your analysis, you want to include a conclusory sentence. So you're concluding and forecasting as to what your analysis is about to discuss. So you have here the Li family contracted Deke to engage in ground disturbing activity to reinforce the property, not to unearth a burial site. So you're literally going to be analyzing the purpose of the excavation, and you're going to then plug it into the language of the rule. And so now each sentence is going to do that. Because they hired Deke to excavate the back of the property as a means of reinforcing it, the Lees made an unanticipated finding of burial goods. So here you're using the language of the rule, which is an unanticipated finding of burial goods, and you're connecting it with this qualifying statement to the important facts. Because they hired Deek to excavate the back of the property as a means of reinforcing it. So you're weaving together the important fact with the actual language of the rule. This makes it an unanticipated finding because they had a different purpose for the unearthing the burial goods. It wasn't to actually unearth them, it was actually to excavate for a different purpose. And then you say the discovery was also unintentional because the Lees only recently moved to the island and thus would likely not understand the legal or cultural significance of native Hawaiian burial sites. So you're using the fact that the Lees have only come to Hawaii and using it in support of your argument that this was unintentional. Unintentional actually speaks to the language of the rule because it talks about the discovery being unanticipated or inadvertent. Sorry, y'all, or inadvertent. And then moreover, we continue the discussion. Moreover, Deek's fearful response about potentially uncovering Iwi Kupuna and abruptly removing his equipment from the property also indicates he was surprised and that the burial site was an inadvertent discovery. So you're using the important facts and you're plugging them into the important language of the rule. The important language of the rule here is you're using everything you can from the facts to show that it triggers this inadvertent discovery from the rule, from the statute, and from the regulation. And then you're concluding. So now you're concluding as to the inadvertent discovery. And again, it can be short. This one could even probably be a little bit shorter because your thus therefore statement is a conclusion of all the hard work you've already done in the argument. You already have a whole bunch of applications of important language of the rule to the important fact, and you've combined all of those and connected all of those and made those connections with the book cause statement or the equivalent of the book cause statement. But notice you kind of have to then conclude for the entire subpart A and subpart B, because notice that you have then this full conclusion. This is going to be your overarching conclusion for your Roman numeral 1. So this is your overarching. So you have to conclude completely for both subpart A and subpart B. And you do it here when you say a court will likely find that the Lees did not violate Hawaii state law. And then you provide the book cause statement. Good. So let's just go, we're going through the second part. The second part actually includes case illustrations. So I'm going to concentrate mostly on the case illustrations in the second part, in Roman numeral 2. Again, it gets a Roman numeral 2 because it's a completely different issue than the Roman numeral 1. So notice that you have your overarching, so now we're back to an overarching conclusion because we're in the new legal issue, which is completely distinct from the prior one. So Roman numeral 2, completely new issue, not related to the other. So it gets its own overarching conclusion. We drop down the overarching conclusion. Notice that it has a book cause statement. So he's entitled to a partial refund because although Deek's performance was made impossible by law, his local and professional knowledge made the discovery of the burial site foreseeable. So notice you're forecasting and telling your reader that you're going to discuss the impossibility by law, and you're going to discuss the fact that the burial site was foreseeable. So the overarching is setting up all discussions that are to follow. The first sentence is going to be a transition. It's going to be a transition between the overarching conclusion, overarching rule. It's also going to step the rule out, and it's going to step the application of the rule out a little bit. And then once you do the transitional sentence, you're then going to go into your funneled rule. So you're going to start funneling the rule. So first you provide the rule for what makes a rule impossible or impracticable. So a contractual duty of performance is discharged when a party's performance is made impracticable without his fault by the occurrence of an event, the non-occurrence of which was a basic assumption of the contract. And then you provide your citations to your case law. Notice that IA Alani is first before Warner, because Aelani is actually the higher authority. It's from the Supreme Court of Hawaii. Also notice that the case law is coming before the restatement, and that is because Hawaii has not adopted the second restatement of contracts. It still is going off of common law. So the restatement is not adopted. So since it's not adopted, it's only going to be a secondary authority. But notice it's still okay to cite it because it's considered a revered, well-respected, highly valuable secondary source. So it actually can be cited. So then you're going to move on to the next rule. So then in your rule block, you're going to provide all the relevant rules and narrow down to them. All of these rules will apply to all of the discussions below. So you've put impossibility, and now you're dropping the rule for foreseeability. Even if performance is discharged, both parties may be entitled to restitution. However, damages are recoverable for loss that the breaching party had reason to foresee as a probable result of the breach when the contract was made. And then you're citing your authority for that, which is Warner. And then you're also providing the short form for the restatement of contracts. And also notice Warner is also in the short form here. And then you're going to go to your app. You're actually going to start going. You're going to go to your your rule block. Sorry, your rule block. Notice though that before you do your rule block, there is one sentence here, and what you do is that if we look at the other page again, when you want to dismiss an issue, you often will put that dismissal sentence right at the end of the rule block, but right before the roadmap. So we have our rule block here, and right at the end of this, we're going to put this dismissal sentence, and it comes right before the roadmap. The language that says this memorandum will show is your language that introduces the roadmap. So we're dismissing the issue of the contract not being properly formed, and we're dismissing that the statutes of frauds has not been met. So we're just saying here the contract between the Lees and Deke was properly formed, and the statute of frauds has been met. So these are being dismissed as being an issue at all, so that we can then just turn to what is the issue. The roadmap will then tell you what the issue is. And so the roadmap is essentially going to forecast for the reader the relevant rule and also the ways in which you're going to apply the rule to the important fact. So this memorandum will show that the Lees are likely entitled to a partial refund because although Deke's performance was made impossible by law, his duty is not discharged because as a local professional excavator who works with the land, Deke understands the legal and cultural significance of native Hawaiian burial sites, not to mention the occurrence of them in the Lees neighborhood, and thus should have been able to foresee the discovery and contractually guarded against it. So it's long. It's long. It's okay to have a roadmap that's 2 sentences. If this feels uncomfortably long to you, you can break it off into 2. You could have handled the impossibility issue first and then addressed the foreseeability issue, or you could actually have it in one long sentence, provided it's grammatically accurate. So once you've set up the roadmap, you're going to then actually go. So you've done your R, you're actually going to go right into your case illustrations. So the first case illustration is Aelani. But notice before the case illustration, there's a stylistic device that you can use, which is helpful for the reader. Notice that right before you get into Aelani, you drop down the principle of law that the Aelani case represents. So Aelani represents the fact that impossibility excuses performance when a government regulation or order is an event, the non-occurrence of which was a basic assumption on which the contract was made. So this is called the thesis sentence. This thesis sentence just states the principle of law, that becomes represented by Ailani. And the reason that you don't have to cite the principle of law here is because the entire case illustration stands for that thesis. So then you drop down your case illustration. Now, a really good case illustration is nothing more than including the court's holding, the important facts that you're going to analyze with your facts from the instant case, and then also the court's reasoning. So provided you have those three things, you have written a really good case illustration. So just make sure that you have those three things in your case illustrations when you do the immigration. You guys are definitely going to have cases in your discussion sections. You will not, and let me repeat that, you will not be doing a rule-based analysis. You're going to actually have cases that interpret the important section from the immigration law that you're working with. So have those three things: the holding, the important facts, the relevant facts that you're going to use to analyze, and also the reasoning. And then after you're going to stack your case illustrations. So here we're stacking the one case illustration for impossibility, and then returning to foreseeability, and also stacking that case illustration, because we're going to analyze both of them below in their own separate paragraphs. So here before we talk about Warner, so notice that this is another case illustration in Warner, but before we talk about it, we're going to actually write another thesis sentence. So the thesis here is that loss may be foreseeable if it follows from the breach in the ordinary course of events or as a result of special circumstances beyond the ordinary course of events that the party in breach had reason to know. So this is essentially the principle of law that you would have located in your research. Many of the secondary sources spoke about this principle. Many of the treatises on contracts spoke of it, and many of them cited Warner for it. So you can drop down the thesis sentence, no citation, because Warner becomes the citation for the principle. So then you say, and then you drop down the Warner holding, and you drop down the important facts, and then you drop down the reason for the rule. So the reason: the court did not excuse the defendant's breach of contract, so that's the holding. And then here's your reason: because he should have been able to foresee and provide against the contingency. And then once you do your case illustrations, your next step in your CREAC is you are then going to do your analysis. So in the analysis, just like in the earlier section, your first sentence is setting up what the application of the rule to the facts is going to be. So your first sentence here to function as a transition before you provide provide your argument is here: Deek's performance was made impossible by law, like the Ailani defendant. And now you're going to actually start analogizing that. And so this sentence sets up that what is about to become the fact-to-fact comparison between the Ailani defendant and Deek. So we start off right away. We say there, the defendant entered into an agreement to obtain referrals, not anticipating the enactment of the federal law, making such referrals illegal. And then you drop down the citation to Ailani, and now you turn to your case similarly. So here we're doing a fact-to-fact comparison across multiple sentences instead of in one sentence, which is fine. You have multiple styles. So we do Ailani first there, and now we turn to Deek, and we drop down the similar fact, and we go similarly. When Deek agreed to excavate and shore up the hillside, he did not expect the contract with the Lee family to become illicit by the discovery of Evie Kapuna. So this is the comparable fact in Deek. So the defendant in Ailani didn't anticipate the referrals becoming illegal, just like Deek didn't anticipate the contract becoming illegal upon the discovery of Evie Kapuna. And then the Aolani court, we continue it. Here, the Aolani court excused the defendant because following through on the agreement would have violated federal law. And so now the holding becomes very similar. So sometimes you put the holding within the same fact-to-fact comparison, but you don't have to. But you do need to drop the holding of the precedent case somewhere within the analysis paragraph. Here, it's coming as a standalone. So first, the Aolani court excused the defendant, and then you go similarly, DEAC continuing to work would have resulted in the excavation of EV, an alteration of the burial site in violation of Hawaii law 6C72. So this is the comparable fact. This is the comparable holding that you want. So you want the Aolani holding that the court excused the defendant because were he to pursue the agreement, it would have violated federal law. You want that exact same holding here. Similarly, DEAC continuing to work would have resulted in the excavation of EV, an alteration of the burial site, which would be in violation of Hawaii law. And then you continue, you provide additional support for the fact that there was an order, a government order. You say that CHPD also expressly told the Lees that the excavation could not go forward, and that stopped the excavation and also makes it similar to Aolani. And then you conclude, so you're finishing the analysis here and you're concluding with your thus. Again, it can be short. Thus, a court will likely follow the reasoning of the Aolani court and excuse DEAC's breach of contract because performance became impossible by law once the moeapu were discovered. And then you move on to Warner. So you finish the analysis for impossibility, and now you move on to the analysis using Warner as your precedent case for a fact-to-fact for foreseeability. But you have to introduce that first, you have to introduce it with that first sentence has to be an introductory sentence that concludes as to what the analysis is going to be. So here you say, however, even though performance was impossible by law, DEAC still owes the Lees a partial refund because, like the Warner defendant, DEAC should have foreseen the damages and contractually guarded against them. So you're essentially foretelling the reader and foreshadowing what the argument is about to be. So the next sentence becomes the fact-to-fact comparison. This one is actually done in one sentence, which is a different type of style, versus the one that we just looked at for Aolani, which was done across several sentences. So here we have, similar to the defendant in Warner, and this is the thing that we're comparing, who had the professional advice of a realtor, and then you're dropping down the holding as to why this was important, which the court found gave him the foreseeability to provide against the contingency of needing his wife's signature on the real estate contracts. And then now you're going to compare this to the relevant facts in the instant case. Here, that word indicates the comparison. DEAC, as a Hawaii resident and professional excavator, so these are his professional credentials, which are just like the professional credentials of the realtor, who the defendant got advice from. DEAC should have been able to foresee the risk of unearthing moeapu, particularly in the area of the rail project, which had been slowed by the discovery of native Hawaiian burial sites. So in the fact-to-fact comparison, you also then end with the citation. This author also, because the author brings in the fact that the rail line, which is where the Li family property is located, had been slowed by the discovery of native Hawaiian burial sites, this author decided to include the citation to a relevant law review, which is okay. Also could have done it in a footnote. And you would include it here and not in the rule statement, because this is really a see also. This is providing an additional fact that any local resident of Hawaii would know. And it does become important that DEAC is local, because having local knowledge actually impacts whether or not he should have been able to foresee the discovery of moeapu. But the important thing here is to note this style of analysis of a fact-to-fact comparison. So again, notice how you set off whether you're doing an analogy or distinction. So here it's an analogy because you're saying similar to the defendant in Warner. And then right after that, you're indicating what you're going to compare. So similar to the defendant in Warner, who had the professional advice of a realtor, and then drop down the holding before you connect it to your case, which the court found gave him the foreseeability to provide against the contingency of needing his wife's signature. And then you go here and then connect it to your case. Deke, as a Hawaii resident and professional excavator, should have been able to foresee the risk of unearthing moepu. And that becomes your fact-to-fact comparison. Notice that it's balanced. You're discussing the same things on both sides. This is a balanced comparison. On one side, you're talking about having professional advice in the Warner case, and on the other side, you're also talking about having professional knowledge and advice on the other side. And that is what lends to the person having foreseeability. So just always make sure that when you're doing your analysis for the immigration issue, just make sure that when you look at your fact-to-fact comparisons, they should be balanced in this way. And then the analysis continues with some other facts that might speak to foreseeability. The immediacy and urgency of Deke's actions also color his foreseeability. And then a couple of facts, the writer drops down a couple of facts that show foreseeability. And then at the end, the writer concludes he has the necessary experience and knowledge of local property and burial laws, as did the realtor advising the defendant in Warner of real estate laws, and so he should have been able to foresee the discovery of moepu and protected against it in his contract with the Li family. So this would be the conclusion. This would be the conclusion sentence to the analysis of foreseeability. But don't forget, you then have to conclude for the entire Roman numeral 2, for the entire contract issue. So then you have to drop down your thus therefore statement for the entire contract issue. So then, the contract issue, so the thus therefore is here. And notice that it also includes its because statements. And then you have to conclude for the entire memo. So you have to conclude for both the Roman numeral 1, which was the E.V. Kapuna issue, which was broken down into a subpart A and a subpart B. 1 for the burial, discovery of the burial site, and 2 for the inadvertent discovery. And then you had to conclude for the contract issue. So you would have to conclude again. But notice this conclusion operates very much as a bookend to the overarching conclusion that we saw earlier. And notice that they all function as bookends. So this this conclusion here is a bookend to the Roman numeral 2. This conclusion is a bookend to Roman numeral 1 and 2, but this one is a bookend just to Roman numeral 2 because we saw that earlier here, because this is the overarching conclusion. So this overarching conclusion is going to be a bookend because it's very similar to this conclusion here. And so all throughout the memo, you have your bookends. And even within your analysis section, you have bookends. So this conclusion to the analysis about foreseeability essentially is a bookend to your conclusory sentence at the beginning of your analysis. This is the bookend. And the same thing here for your impossibility issue. You know, you're concluding here, but this is essentially acting as a bookend and has similar language to what existed here when you started the argument. So all throughout legal writing, you're sort of doing these bookends, and you'll do that same thing for the immigration issue. So why don't we actually turn to the immigration issue. In doing that, though, I'm also going to have to show you how to convert your question presented and your brief answer, which you might not have any experience with, that the the book A Lawyer Writes does discuss for you, but I'm going to show you how to convert them into an introduction, because we're going to want you to write an introduction for your persuasive memo. So let me actually just show you the parts of the memo. So this was the template that we sent out. So this template we sent out, and this is the one that we're going to use for the immigration issue. So we gave you the caption, and you're going to literally stick with it. We gave you the caption for the memo. We gave you the beginning header for the memo, and also the first couple of sentences, which essentially tag the memo. These are very common and traditional. So these we want you to actually provide exactly as written. We didn't want for you to have to draft it yourself. So we just kind of did it for you, because you guys have more important sections to talk about. And then in the introduction is essentially going in the first sentence, concisely state the conclusion of law. Over the next few sentences, you're going to indicate the determinative facts, which will essentially give up the nature of the case. And if you have it, you're going to provide procedural postures and any motions before the court, if you have it. And then in your last few sentences, you're essentially going to apply the law, apply the rule of law to the important facts. And then that's the only new section, which we'll talk about. And then the statement of the facts you have experience with. You're also learning how to write them persuasively in LF2. You'll do that same thing here. So don't forget, unlike an objective memo, here, if it helps your client, you might want to include some facts that are maybe emotional in nature, that don't actually necessarily go towards the application of the rule. You might include those. You might maybe minimize any facts that hurt your client. And you might do that by using the passive voice, or you might do it by dropping them in the middle of a paragraph. But don't forget, you can't not include them. You just have to minimize them by being strategic in their placement or in the way that you use your phrasing grammatically. And then you're going to provide the argument. And in the argument, we gave you your Roman numeral 1. Oftentimes, when you're submitting to a federal court, they want the standard of review to be up front and center, because this is the lens that the court views your entire argument through. So you have to remind the court front and center what their responsibility is in terms of the way that they look and the way that they consider your arguments below via the standard of review. So it goes up front and center because it's very important. And then you will then move on with your argument in the later Roman numerals. So for us, we're only going to have a Roman numeral 1 and 2. The Roman numeral 2 is going to be our only argument, and we're going to break it up into an A and a B, which you just saw from the Li matter. So notice that it's going to follow the CREAC. So in the header, you're going to give your overarching conclusion as to the immigration issue for both your subpart A and your subpart B. And then you're going to drop down your overarching rule. Your overarching rule will also apply to both your subpart A and your subpart B. And again, you saw both of these, and you saw how they worked for the Li matter. And then for your first issue, you're going to put the conclusion for it in the header next to your subpart A. And then you're going to drop down the rule that only applies to subpart A, the cases that only apply to subpart A, and you're going to stack the case illustrations one on top of the other. And then you're going to do the analysis, and then you're going to have another mini conclusion that'll act as a bookend to your conclusion up here. And then you're going to move on to your subpart B, which will be your second issue. So the rule will only apply to subpart B. The cases will only apply to subpart B. And I will tell you that you will have different cases for subpart A and subpart B. They will all be different. You're not going to use the same case for both of these subparts. And then you'll have your analysis, and then again your bookend for your conclusion. But then you're going to have to conclude for both A and B in your final conclusion here. And then you're going to include these addendums or addenda. So you're going to include your table of authorities, and we'll look at that in the Li problem. And then you're also going to include your research plan, which please make your research plans very comprehensive. 50% of the grade is the research plan. And so the research plan is a kind of a quick way to get 50% of your grade. Hopefully it's graded. I honestly hope that we stay on a graded semester, but we'll see. We'll see. If not, still work really hard on it. And then the final piece is going to be a one-page reflection on the research process. So why don't we look at those sections that you haven't done. So let's go back to the Li problem. I want to show you how to write the introduction, how you would have written the Li problem as an introduction. So this screen is essentially showing what we just saw from the Li problem. We saw a question presented. These were the questions presented for the Li problem, and also the brief answer for the Li problem. And what I've done is I've put them in a sort of a color coding to show you that essentially your question presented and your brief answer becomes an introduction. They all have the same parts. You're just organizing them a little bit differently. So notice your question presented will sometimes have, well, always has relevant facts that are within the question. Sometimes they have more relevant facts in other issues, in some issues than others. This one doesn't necessarily need to include all the relevant facts. You will supplement these determinative facts in your introduction. So the blue is for your relevant or determinative facts. The red is for the answer to the question or the conclusory application of the rule to the facts. So you're essentially answering the question with the red. The green is your rule of law. The purple is the application of the rule of law. So the application of the rule to the facts. And then the orange section is essentially the conclusion, which functions to bookend the red sections, which were your conclusory statements about applying the rule to the facts. So notice that for the Li problem that we saw, that we just talked about, so we had the conclusory sentence first, and then we had the rule of law drop down second, and then you apply the rule of law with any relevant facts or determinative facts, and then you concluded. And the conclusion was here at the bottom. Since Deke reported the Li family's name and residence to DLNR in a timely manner, they have likely not violated Hawaii state law by inadvertently discovering a burial site. So that was the conclusion. Now in the introduction, if you notice, the introduction takes the same pieces, but just reorganizes them a little bit. So notice that the conclusory sentence, the answer to the client's issue, goes front and center in the first sentence. The Li family did not violate Hawaii state law when their excavator Deke unearthed Moepu because the burial site was inadvertently discovered and immediately reported. And then the thing that's different in the next couple of sentences, the introduction will drop down the most important facts. And oftentimes those most important facts reveal the nature of the litigation. And then if you have them, you would also include any procedural postures or any motions that are before the court in this section. So for us, we don't really have any procedural postures or motions. We just have facts that speak to the nature of the litigation. So you drop down those facts here. And then in the second paragraph, you drop down the rule of law in the first couple of sentences. And then in the next couple of sentences, you make a quick application of that rule of law. And that is also a little bit different from the brief answer, because notice the brief answer does the opposite. It puts the rule of law in the first paragraph, and then the entire second paragraph becomes the application. But in the introduction, it's actually the opposite. the rule of law is in the second paragraph, and the application is a little bit more concise, and it's dropped down right after it. So for your introductions for the immigration issue, you're going to conclude as to the issue, to PIA's issue. You're going to drop down the facts that speak to the nature of the litigation and any procedural posture from the case. And then you're going to drop down the rule of law having to do with the crimes involving moral turpitude, and the ones that the state law ones that have been triggered, and how the two of them actually sort of work interchangeably. Because remember, you're answering a federal law issue with some discussion of the state law. So there's a symbiotic nature about them that you're going to have to explain. And then you're going to drop down the application of that rule of law. And that's where your explanation would be. And that would be your introduction. That's essentially what you're going to write. So this introduction here, this introduction is essentially going to drop down here. It's essentially going to drop down right here. And I will, and hopefully it won't be too challenging to write. It does have a formula, and if you've noticed, everything about legal writing, for the most part, is a formula. And what it does is that formula just kind of frees you in a way, because you know that you're restricted with what you can include in certain sections. And I just talked about sort of those restrictions within the introduction. Every sentence has its purpose, and when I walked you through the Li matter, hopefully I emphasized the fact that every sentence within a section has its purpose, and often each section will be bookended. So the bookend is the last sentence that's concluding with the thus therefore is very similar to the first sentence, which is introducing the application of the rule to the facts. And then the other pieces, let me show you finally the other pieces for the Li matter that you're going to include for the immigration piece. So for the other pieces, you're going to, once you conclude with your memo, so this would be the table of authorities for the Li matter. Actually, let me show this to you in a different screen because it's actually not showing it correctly. Let me show it to you. So this would be the table of authorities for the Li matter. Notice that you're setting it up according to what you've learned about setting up your table of authorities from the lectures in the plenary. And also notice that the table of authorities is in order of highest authority to lowest authority. So your Constitution is first, followed by the statutes, the regulations, cases, and then the secondary sources. And even your secondary sources actually have a most persuasive and a less persuasive. The Native Hawaiian Law Treatise would come first before the restatements because they're probably more persuasive than the restatements are. So you probably would put those first, since we're dealing with the local issue also is the one that's addressed first in the memo. And then after you do your table of authorities, you're going to do your summary of the secondary sources. So this is your reflection, essentially. This is your reflection. If you notice when you look at it at home, notice that it discusses at least 3 secondary sources that were significant, and it also explains why they were significant. Like, for example, here, the Native Hawaiian Law Treatise was significant because it provided a framework that explored how the Hawaii Constitution gives the state the power to conserve and develop objects and places of historic or cultural interest. It also tells you that it summarized the definitions of the key terms. So you have to explain why the secondary source was important. You should discuss at least 3, And you should also explain the purpose of the resource and also why the resource was particularly important for your research and for your analysis and for your drafting of the memo. It might just be important because you located, the relevant authority, just like the author here states about using the ALR, because through the ALR, I was able to find the case Aolani Court versus Hawaii, which I would use as a case illustration for the first issue. And that's a legitimate reason for why a secondary source becomes really important, because it gave up the governing law. And then after you do the reflection, you're going to drop down the research plan, and it can honestly be in either order. I think the template shows the reflection coming last, and that's fine. That's totally fine. So you're going to drop down the research plan, and I've already discussed the research plan. Just please make the research plan very detailed, very thorough. Notice that I'm using more than one search string. Notice that I'm including more than one reference to the treatise. I'm doing more than one treatise. I'm doing more than one law review and journal. Notice that in the statutes, I'm talking about more than one statute. I have several statutes. And notice that in the notes section, I give detailed notes, detailed explanations of the rule that I'm going to use in my memo. And I do that all throughout. Regulations, make sure you do the same thing that you did for statutes, that you'll do the same for regulations. And then for the contract issue, I just continued on and provided more than one search string, whether or not I use the table of contents or the index, more than one section of the treatise, several sections of the treatise, several sections of the encyclopedia. And also importantly, I put in key numbers. So you should, in your research plan for the immigration problem, you should definitely include several key numbers that were helpful to you, not to mention several cases. You should mostly have a ton of case law. So for our issue, we only had 2 cases because not a lot of authority in Hawaii here for the Li problem actually discussed the contractual issue. But since you're doing a federal issue for the immigration law problem, you should have a ton of cases that you had considered before you chose the ones that you did for the memo. So most of your research plan will be case law. It will not be statutes and regulations because we give you the statute that we want you to discuss. So you won't have several statutes. You might have a couple of regulations because you can include a regulation in your rule section, but you should mostly have a ton of secondary sources to help you understand the immigration problem and a ton of cases that you considered before you actually chose the ones that you did for the argument. Okay, guys, I think I'm going to stop there. I apologize that this is so long. I know, following along, with my discussion of each sentence in the memo is maybe not an ideal way to teach writing. I would much rather do it if you were in front of me so that I could gauge your reaction. But I can't stress enough that becoming a better writer really happens in a one-on-one conversation about your particular work and about sort of the particular roadblock that you're having with your writing. Because everybody has a unique issue that they need help with. And so it's hard to do in a classroom setting. I hope this was helpful in even a small way, but I would promise you that if you set up a one-on-one and we can just discuss your particular writing, it'll be a lot more helpful if we're really discussing you and discussing your own work. That'll probably be more helpful to you. But I hope I was able to break down the CREAC format. The other thing I want to leave you with, though, and I maybe should have brought this up in the beginning, is that I created a research guide that my students from LF are familiar with. So I created this research guide that breaks down each section of the legal memo So I'm just going to scroll through it here, and I explain each section. And then the other thing I do as well is that I explain each section here on the left-hand side. So if I wanted to know more about, writing a good, if I wanted to know more about writing a good, let me see, overarching conclusion as an example, I'll provide an example of a student's overarching conclusion, and then I will explain what needs to be edited here. And then I will show the edited section, and then I will explain why the new section works better. And I try to color code everything so that it makes more sense. And then I also give you a checklist for what you should consider before you submit a final work. So you can use this checklist to make sure that your overarching conclusion, as an example, has all of these things displayed. Same thing with like the case illustrations. I take you through a student's case illustration. I explain why it needs to be corrected, and then I show you how the case illustration has been improved and color code everything. And then I also give you a checklist for how to make your case illustrations better. More importantly, I do that same thing for the application. Because the application section is so important, I give you two different examples. So I give you the one example here. So I give you a student's analysis. I explain why the analysis needs to be improved. And then I show you the improvement, and then explain why it's better. And I give you two examples because the analysis is the hardest part to learn in legal writing. So I drop the second example here. And I also give you a checklist for what to consider when you're writing an application section, when you're doing the analysis. And then the discussion that I had today with you about converting your question presented and your brief answer into an introduction for a persuasive brief, I added that to the research guide. And so I used a different example. I used the example that I had been using in the research guide about equitable adoption. So it gives you another example to look at aside from the one that I sent you regarding the Li matter. So check out this research guide. It might help you, and also you'll be able to spend more time with it than you can, re-listening if you were to re-listen this lecture, which I don't know. I don't think I would re-listen to it, but I hope it's helpful in some way. And again, reach out to me. Send me an email if you are looking for a one-on-one discussion, but either about your research or about your writing. So about the research, I will entertain that as well. And again, I don't know what the school is going to do about the credit, no credit, whether or not we'll be graded. I have no idea. But I would just, again, please use this opportunity to practice the skill. It's really important that you become pretty stellar researchers and writers, because the entire practice of law is built upon that. The entire, advocacy and justice is all built on you being able to communicate and persuade on behalf of a client. And so it becomes really important that you can do, really important to demonstrate and put those skills, into effect so that you can improve people's lives. And the only way to do that is to be able to argue, clearly and concisely on their behalf. And the only way to do that is to practice, and it's a lot of practice. So regardless of what goes down with the vote about credit or no credit, treat this like it's graded. And I promise I will give you a ton of assistance and a ton of feedback. Miss you guys.